distinguished speakers who are political heavyweights in their own rights to do justice to the subject. Ladies and gentlemen, welcome to the 6th Leadership Dialogue series of the Center for Social Justice. The Leadership Dialogue is our flagship civic education platform for rigorous intellectual discussion on a broad set of national issues by engaging prominent national leaders. And I can assure you that you're going to have a wonderful time. I would just want to start by acknowledging the team that I'm working with, as I like to joke and say that this is increasingly beginning to feel like a television production. So I'm working with Priska Atoxia, who is providing technical support, and then supported also by Stephen Kemeche, my brother, and George Ferguson Lane, the communication grandmaster himself. Before we kick into the main proceedings, I would want to yield the stage to a co-facilitator for this morning, Bashiratu Kamal Muslim, who is a member of the Council of the Center for Social Justice and also the fellow overseeing the Gender and Social Inclusion Pillar. As many of you know, March is the month for International Women's Month, and we are celebrating women playing various leadership roles in the fight against COVID. So Bashiratu is just going to give us a snapshot into some of the thinking of the Center for Social Justice for this month of March, as we prepare for detailed programming for gender a bit later on in this month. So Bash, over to you.
Thank you so much, Doctor, and a warm welcome to participants and our esteemed panelists for this evening's discussion. I will briefly introduce the gender pillar of the Center for Social Justice to everyone, and then towards the end of the program, I will briefly discuss and introduce you to our new program that we will have coming up soon. So the gender pillar, the gender and social inclusion pillar of CSJ is focused on working to liberate women, working for the emancipation of women. And as we all know, we live in a patriarchal society where systems and structures contribute to the oppression of women in terms of access to opportunities, access to employment, and access to natural resources. So the gender and social inclusion pillar looks at also including other vulnerable groups in society and not just women. So we look at young women, we look at children, and we look at persons living with some form of disability. And our work is also going to be highlighting rural women as a part of a group, a special group we'll be looking at. We are looking at activities that will be responding to issues around women's access to resources, land. People also might have access, but may not be able to control the resources that they are a part of. Then we are looking at issues around equal opportunities for everyone, employment, education, equal opportunities in health and other things. Then economic empowerment of women, because without being economically empowered, how do we expect women to participate in political activities? Since for politics, we all know that you should have a base and a foundation before an investor will agree to even invest in you politically. Then the promotion of rights of vulnerable groups, like I have already mentioned, and also bringing forth activities and programs that is targeted towards bringing interventions that support the emancipation of these vulnerable groups that we are focusing on. And one key area that we also focus on is issues around sexual and gender-based violence against vulnerable groups. And with the COVID coming in, the emergence of COVID exposed all of us, not just in Ghana, but in the world, because yesterday when the Secretary General of the United Nations gave his speech at the opening of the UN Women's CSW, he did mention that over 38% of women and children have been reported to suffer some form of gender-based violence as a result of COVID, and especially during the period of the lockdown. And Ghana is no exception to that, because we've also recorded cases relating to rape, defilement, incest and abuse, cyberbullying, because a lot of people were online. So the center also will focus on issues around these gender-based violence to support women in realizing their full potential. How do we do it? We are going to do this not on our own, but with support from every one of you, individuals, cooperatives, institutions, and funding agencies that are open to working with us on any of the issues that I have mentioned. And thank you and welcome again. And by the time we close this program, I will be so happy to introduce you to our upcoming program. Over to you, Soji.
Thank you so much, Bash. That was wonderful. And I certainly know that the matter of sexual and gender-based violence has really come to the fore with some of the recent murders that have been reported in the media. And I know that we are going to dedicate some more substantive programming to address those issues. So that's good. I mean, for those of you who are not new to CSJ's programs, you know that we try to be as interactive as possible. So kindly make use of the chat function. If you have comments, if you have questions, as the speakers deliver their addresses, it will be good to just chat in. And then also for good sound quality, if you're not speaking, if you kindly stay muted, that would also be very helpful so that we only leave the mic for the person speaking and then there's no interruption. So now the plot is thickening and we do not want to assume that everybody has read the 50+ page judgment of the Supreme Court. So we are very honored to have our in-house counsel, Theodore Albright, who is a member of the council, but then also working as our lead for legal and constitutional affairs, to shed some light and to set the scene for the discussions that would emerge. What did President John Mahama take to the Supreme Court? What were the issues that were set out by the 7-member panel? And what were the decisions that were reached in the judgment? So just briefly capture that for us, and then we can go on to our first keynote address. Theodore, over to you.
Good evening, esteemed members and listeners. And so following the judgment, I beg your pardon, following the elections on the 7th of December, the National Democratic Congress went to court seeking 6 reliefs. The first was a declaration that the declaration which was made by the Electoral Commissioner was in breach of the Constitution. Second, another declaration that the data upon which the candidates sought to base the collation of the results was not satisfactory. Third, that the results, therefore, should be annulled because it was null and void. Fifth, that there should be an injunction against President Nana Akufo-Addo from holding himself out as the president. And lastly, an injunction mandating and directing the Electoral Commissioner to proceed a second election, i.e. a rerun. When these reliefs were brought to the Supreme Court in their wisdom then collated the issues and set out 5 key issues for determination. And the first issue was whether, in fact, the petition that had been presented disclosed any reasonable course of action. They wanted to determine whether the case was frivolous, and in their infinite wisdom decided that the assertions and allegations being made were so severe and serious that it warranted a hearing by the Supreme Court. Second, whether based on the data contained in the declaration, which showed that Nana Akufo-Addo had won the election was valid, because the assertion that was made by the NDC was that no candidate obtained more than 50% of the valid votes cast. And in their wisdom, they chose to deny the NDC that privilege, holding that by any form of calculation, Nana Akufo-Addo did obtain at least more than 50+1 votes, as was required by Article 63, subsection 3 of the Constitution. Thirdly, I wanted to know whether by excluding the numbers from Judgement South, that would modify the ultimate outcome of the elections, i.e. the 50+1. And by their calculation, it was clear that whether you added it or you didn't add it, President Akufo-Addo still obtained the 50+1 percentage needed for him to be declared as the president. And then the fourth issue was whether or not the declaration was in violation of section 63(3), which is that it must be fair to all the parties. And they held that to be the case. The last issue which was considered was whether or not there was vote pardon, and whether the errors by which the vote pardon caused were significant enough to alter the ultimate outcome of the election. Again, looking at the figures, the Supreme Court decided that the numbers were not significant enough to have altered the calculation of the 50+1 results needed by the Constitution for Nana Akufo-Addo to be declared the President of the Republic of Ghana. And so all told, in all the 5 issues that were raised, the Supreme Court decided against the NDC, save for whether the petition disclosed any reasonable course of action. Interestingly, I think there are lessons that we can draw from the whole petition and the judgment. And I think the first lesson for both parties is that in going to court, one must have a strategy of the desired outcomes and the expected outcomes, and those have to be clear. Second lesson is that one should marshal one's evidence, be it oral or documentary, for presentation in the court. Third lesson, which is not so much in relation to the court case, but the whole election machinery, is that both parties should have a robust system in place to enable them to collect accurately, collect promptly all the results from all the regions, from all the constituencies, enabling them to have speed to make decisions and authenticity as to whether or not the candidate has indeed secured the necessary 50+1 to be declared president of Ghana. I will stop here and allow my esteemed honorable members to now carry on the discussion as to the Supreme Court decision and what lessons we can learn for the future. Thank you.
Thank you very much, Theodore. That was very well put. And as you ended, the focus now, having set the scene so brilliantly, will be to look forward. So this will not be just a matter of unpacking the case, but to look forward as a country, including the lessons that we can pick to strengthen the system. And I see that you called out 3. 1, be very clear on the expectations as you go to court. 2, to be able to marshal the requisite evidence to be able to state the case. And 3, to come up with a robust machinery as a party to be able to assure yourself of the integrity of the vote. So thanks a lot. And with that, I will call on Bash to introduce our distinguished first keynote speaker. Bash.
Thank you, Soji. And welcome once again, everybody. I will introduce, I have the honor to introduce Mr. Peter McMenu, whom I can never forget in 2016 when he was interviewed from the NPP, should I call it, strong room about the phase of the election, and he boldly declared the election. So Mr. Peter McMenu is an international consultant on center-right political party organization, as well as a campaign manager and election strategist, and we have seen this. He's currently the vice chairman of the Munich-based International Democratic Union, IDU. In the 2016 general elections, Mr. McMenu managed Ghana's new patriotic party's national campaign to victory. Again, in 2020 general election, he led the campaign team to another victory. He has represented the new patriotic party on Inter-Party Advisory Committee, IPAC, of the Electoral Commission of Ghana from 2005 to date. He also attended several workshops across the globe, including Nigeria, Kenya, Cote d'Ivoire, Uganda, Mozambique, Malawi, the United Kingdom, Germany, US, as a resource person on multi-party democracy in Africa, political party organization and management, elections, campaign strategies involving women, youth, and minorities' involvement in politics, among others. He is an international observer of elections and has observed several elections in Nigeria, Kenya, Cote d'Ivoire, Ghana, Uganda, Liberia, United Kingdom, Norway, Sweden, Germany, and a host of other countries. Mr. Menu served 2 terms as chairman of Democratic Union on Africa from 2006 to 2012, and as honorary chairman from 2012 till date. He is currently the board chairman of the Ghana Ports and Harbors Authority and a board member of Meridian Port Services. He has a bachelor's degree.
Can you hear me? Soji?
Yes.
Okay.
Yes, we can hear you.
Okay.
He has a bachelor's degree in accounting from the University of Mrs. Alice Menu with children. And I must say, this is deep. And we are happy to have you join us this evening, Mr. McMenu. Welcome once again.
Hello, Mr. McMenu, welcome.
Hello.
Yes, hello, we can hear you now, sir.
Thank you, Madam Bashiratu, for the wonderful introduction of my good self. And thank you to Center for Social Justice for giving me this opportunity to be part of today's Leadership Dialogue Series 6. Let me first say that I was going to do my presentation on an introduction and background to the petition, something that Mr. Theodore Albright has eloquently spoken about, the background. Then I will like to give a rendition about the petition itself, and then go on to the judgment before I proceed to the ramifications of the judgment on the political, electoral, and legal. Then I will give my conclusion. So that's how I intend to go on with my presentation for this evening. So let me begin with a short introduction or the background, but that has eloquently been done. And I thank Theodore Albright for the good expose of the background to the election petition of 2020. The rule of law is an essential element of a democratic society, ensuring the legitimate expression of the will of the voters, call for a regulatory structure that is fair, clear, and applied equally to all in society. A key dimension of the rule of law in a democracy is the concept of electoral justice, an avenue to seek redress at the Supreme Court. Electoral justice ensures that elections meet high standards of integrity and guarantees that there are mechanisms in place to restore electoral integrity when it has been violated. Article 64(1) of the 1992 Constitution states that the validity of the election of a president may be challenged only by a citizen of Ghana who may present a petition for the purposes to the Supreme Court within 21 days after the declaration of the results of the election, in respect of which the petition is presented. The 2020 presidential and parliamentary elections was conducted and supervised on the 7th of December 2020 by the Electoral Commission of Ghana. Candidates on the ticket of 11 political parties and 1 independent candidate, making a total of 12, contested in the presidential election. At the end of the polls, the candidates of the ruling party, who is President Nana Addo Dankwa Akufo-Addo, won the election with 6,776,966. Of the total valid votes, which represents 51.267%. Indeed, Article 63(3) of the 1992 Constitution clearly states that a person shall not be elected as president of Ghana unless at a presidential election, the number of votes cast in his favor is more than 50% of the total valid votes cast at the election. And I repeat, unless at a presidential election, the number of votes cast in his favor is more than 50% of the total number of valid votes cast at the election. It was on this premise that the chairperson of the Electoral Commission, who also doubles as the returning officer of the presidential election, and the only constitutionally mandated person to declare presidential election results, declared Nana Addo Dankwa Akufo-Addo as the president-elect of Ghana. However, the largest opposition party in Ghana, the NDC, whose candidate, the former president John Dramani Mahama, obtained 6,265,216 of the total valid votes, representing 47.396%, refused to accept the results as declared by the Electoral Commission. This was based on the premise that the NDC, after the collation of their own results, found John Dramani Mahama to have won the elections.
Mr. McMahon, it seems you are muted. Yes.
Thank you. Am I on?
You're on. Excellent.
So John Dramani Mahama filed his petition on Wednesday, 30th December, through his lawyers, and later amended it on 15th January 2021. So now let's look at the petition itself. Just a quick glance. I know lawyer Theodore Albright has already taken us through, but let me do my part. The petition, CI 99 and court rules. In 2012, the NPP and Nana Addo Dankwa Akufo-Addo, for the first time in Ghana's history, contested the validity of the 2012 election results. The trial, since it was the first of its kind, was very delicate in nature. Hence, the Supreme Court had to be very meticulous in handling and determining the case. It lasted for about 8 months until the final verdict was given. As a result of this long duration in determining the case, the CI 16, the Constitutional Instrument 16, which was used for the novelty case in 2012-2013, was amended to CI 99 by the Rules of Court Committee as captured in Article 33(4) of the 1992 Constitution. The date of Gazette notice and entry into force of the CI 99 was 12 October 2016 and 5th January 2017, respectively. The Rules of Court Committee was chaired by the then Chief Justice, Honorable Mrs. Georgina Wood, then the Attorney General and Minister of Justice then, Honorable Mrs. Marietta Brew appear upon, and others. The new CI 99 sets a 42-day period to determine the case in a presidential petition from the day the petition was filed. This is very important because the previous one, we have spent 8 months, and now the Rules of Courts Committee has decided to change the rules to make and limit the time spent on presidential election petitions to 42 days period. And it begins with day 1 filing, day 7 appearance and answer, day 10 pre-trial, hearing, end of hearing, and by the 42 days, we have the judgment. So the court considered the petition from the petitioner and answers from the first respondent, which is the Electoral Commission, and the second respondent, which is Nana Addo Dankwa Akufo-Addo. The grounds on which the petition was filed by John Dramani Mahama, as already captured by lawyer Theodore Albright, are as follows. Claims that none of the candidates who contested the polls obtained 50% of the votes cast. Allegations that Nana Dankwa Akufo-Addo, who won the polls, benefited from vote padding, and claims that Nana Akufo-Addo benefited from arithmetic and computational errors. The petitioner concludes that the Electoral Commission's declaration of Nana Dankwa Akufo-Addo is unconstitutional, and since he did not obtain more than 50% of the valid votes. And he sought some release. As said already, the Legal and Constitutional Affairs expert of Center for Social Justice, Theodore Albright, has already enumerated the 6 reliefs that former President John Dramani Mahama sought. These were that the court declares the chairperson of the EC to be in breach of Article 63(3) of the Constitution in her declaration of 9th December 2020. 2, that the court declares that based on the data contained in the declaration, no candidate satisfied the requirements of Article 63(3) of the 1922 Constitution to be declared president-elect. 3, that the court declares that the declaration made on the 9th of December 2020 is unconstitutional, null, and void, and of no effect whatsoever. That the court annuls the declaration of the Presidential Elect Instrument 2020 CI 135. 5, that an order of injunction restraining the second respondent from holding himself out as president-elect. And then lastly, the court orders the first respondent, as the Electoral Commission, to conduct a second election with the petitioner and the second respondents, as clearly stated in Article 63, 4, and 5 of the 1992 Constitution. I think that lawyer Theodore Albright has adequately treated us to these reliefs. Then the court went on to set the issues for determination. And these have also been adequately espoused by lawyer Albright. These were whether or not the petition, 1, the courts before the trial commenced set the following issues for the determination of the case. So 5 key issues were set for the determination of the case. Whether or not the petition discloses any reasonable course of action. Whether or not based on the data contained in the declaration of the first respondent, that is the Electoral Commission, no candidate obtained more than 50% of the valid vote cast as required by Article 63(3) of the 1992 Constitution. And whether or not second respondents still met Article 63(3) of the 1992 Constitution threshold by exclusion or inclusion of Petition South constituency presidential election.
A little bit of a break, but I'm hoping that Mr. McMenu will join us shortly. And just to say that I want to recognize the presence of Honorable Dr. Benjamin Kumbo, who is going to be our second keynote speaker. He's been able to join us. And to also say that the event is being carried live on Facebook and on Wazer TV. Welcome back, Mr. McMenu.
Thank you. I'm sorry for the interruption. So I was on the issues set for determination of the case by the Supreme Court. And the 5th one was whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. Now, let me go on to the judgment. The Chief Justice, who was the president of the bench, set 4th March 2021 as the final day of judgment. The election petition filed by John Dramani Mahama was unanimously
I think that, yes, hello. So it might be that the video is a little bit on the problematic side because of the bandwidth. So perhaps with the exception of Mr. McMenu, we can switch off our videos to give him the greatest opportunity to present uninterrupted. And then later on, we can come back on. Thank you.
All right, thank you. So the Chief Justice read the judgment on behalf of the bench. And the judgment was based on the issues that was set up for the determination of the case. The 5 issues I have already described above. Based on issue 1, the court was convinced that the petitioner raised a reasonable cause of action, and that the arguments of the first and second respondents that the petitioner had a weak case was not enough grounds for the petition to be dismissed ahead of a trial. So for the case to be thrown out because of cause of action was dismissed and a full trial was allowed. With the second issue, the Chief Justice said there was no doubt that the chairperson of EC made a mistake by using 13,434,574 instead of 13,121,111 to be the total valid votes cast in the declaration. According to him, the 1992 Constitution clearly spells out the requirements needed to declare a president. And that should be based on the total valid votes cast and not the total votes cast. And I think I repeated that earlier. It is based on the total valid votes cast and not the total votes cast. Since the mistake was rectified by the chairperson, it is wrong for the petitioner to hold the EC to the error. Hello? Hello? Hello?
Hello, sir. We can hear you. Please continue.
Okay.
Hello, sir. We can hear you. Please continue.
All right. It is
Hi,
wrong for the
Soji. Hello, Mr. McMenu. If you
Yes,
wouldn't
madam.
mind, you can also try to switch off your video. Sometimes the use of the video also disrupts the network
Okay.
connectivity. Yes, thank you.
Are you okay? Hello?
Yes, you can go on,
Yes,
sir.
hello.
Okay. So let me take this one again. Then it's about the
So we'll be making efforts to get Mr. Peter McMenu back. I think he's having a few IT challenges on his end. And hopefully once he gets his video off, he should be able to stay connected. So apologies for this.
Hello.
Yeah, hello, sir. We can
Yeah.
hear you now.
Okay. So with regards to issue 3, the Chief Justice said that at the time the petition was filed, the results of Techima South constituency election had been added and therefore was known to the petitioner. According to the Chief Justice, the cross-examination of the first witness, Mr. Asiedun Ketia, based on calculations he made, established that the second respondent had more than 50% plus 1 vote threshold. It was further added that even if all registered voters of Techima South constituency of 128,018 were added to petitioner's votes, the second respondent will still make the 50% plus 1 threshold. The second respondent at that point will have 50.79%. The Supreme Court therefore established that President Adodankwa Akufo-Addo crossed the 50% plus 1 vote requirement, even without the results from Techima South constituency prior to the declaration of the presidential election results on December 9, 2020. On the 4th issue again, the Chief Justice held that the error made by the Electoral Commission chair did not affect the results and was not in violation of Article 63.3 of the 1992 Constitution. The Chief Justice pointed out that there was no doubt that the EC chairperson made an error. However, based on available evidence, it was corrected. I mean, the following morning by 8 o'clock, he had made the correction. The Supreme Court held that view that the petitioner also failed to back his claim that the declaration by the EC chairperson was unconstitutional. Finally, on the 5th issue, the Chief Justice said the court finds the accusation of vote pardon very serious, since its occurrence undermines the integrity of an election, but also observed that this allegation was not proven as expected by the petitioner. The CJ said the judges are therefore settled in their minds that if there was vote pardon, it did not in any way affect the outcome of the election results. The allegations was not proven by any credible evidence and therefore would not be enough grounds to nullify the elections. Now let's look at the ramifications of the judgment. Hello?
Sir, we can hear you. Hello, Mr. McMenu, we can still hear you.
Let's look at the ramifications of the judgment. First, the political. A major component
So viewers, ladies and gentlemen, we've just been listening to Mr. Peter McMenu, campaign manager for the New Patriotic Party, trying to speak to the ramifications of the judgment passed by the Supreme Court. He's given us some context. He's given us the issues presented by the National Democratic Congress, the issues set out by the Supreme Court, the judgment that was passed. And I think he's just about to delve into the political, the electoral, and the legal ramifications of that judgment. A few bandwidth challenges on his end, but hopefully he joins us shortly and then takes up from where he left off. very good discussion that is ongoing relating to the petition that was filed by John Dramani Mahama, His Excellency, the former president and flag bearer of the National Democratic Congress. Mr. Peter McMeno, you are about to delve into the political ramification, so over to you.
Thank you, Dr. Soji. Well, I'm now on the ramifications of the judgment, the political aspects. Elections, particularly election results disputes, has been the source of many conflicts and violence witnessed across the world. Kenya, Ivory Coast, Mali, and Senegal are examples of some countries in Africa that have suffered due to election-related problems. It has led to bloodshed, destruction of property, loss of lives, emergence of terrorist groups, and ultimately plunging the economy into total disaster. Many countries are yet to recover from the scars of electoral-related violence and conflicts. In a democracy such as the one we enjoy in Ghana, the Constitution empowers the Supreme Court to independently resolve all election disputes. The issues are dealt with in a transparent manner such that all parties are given a very fair hearing. This puts to rest all doubts in the minds of the people. Ghana's first case of election petition of 2012-2013, the supporters of the then opposition leader, now President Nana Addo Dankwa Akufo-Addo, were highly dissatisfied and agitated based on the declared results, but were calmed down by the candidate and the party. A decision was taken to revert to the courts for redress. After 8 long months of trial, finality was brought to the matter. Then the leader, President Akufo-Addo, accepted the verdict of the Supreme Court and urged his supporters to accept it as well. He telephoned to congratulate President John Dramani Mahama after the court's judgment. He further urged Ghanaians to rally behind his elected leader and help in developing the country. The country moved on from there and have been to successful general elections after that. Equally, we expected the former president, John Dramani Mahama, to congratulate President Nana Addo Dankwa Akufo-Addo after the judgment of 4th March 2020. The petition brought members of the two political parties together on a daily basis. It was seen by many on TV that leading members of the MPP would always exchange pleasantries with leading members of the NDC. This brought one of the most important factors to bear, that politics is a contest of ideas and not war. It was always a pleasant scene to find both sides heartily chatting. These scenes, directly and indirectly, sent a clear message to the support base of the two parties that we are one people who love and respect each other, but only belong to different political parties. A very good example was when Mr. Frank Davis, counsel for the second respondent, and Mr. Justin Amenuvo, counsel for the first respondent, stood in and made a plea for clemency for a member of the petitioner's legal team, Dr. Dominic Ahine, when he was called by the bench to explain why contempt charges should not be brought against him for certain scandalous comments he made about the Supreme Court during a press conference. Ghana remains a politically stable and peaceful democracy. The country is united for the common agenda of its prosperity. Government is picking up quite well. The Parliament of Ghana has recently approved
Well, ladies and gentlemen, I think you would have to bear with us in this modern era amidst the global crisis. With all of these virtual meetings, it looks like we cannot run away from these statements around you are muted and your bandwidth is low and we can't hear you and all of the other things that come along with it.
So can you hear me now?
Yes, we can very much so. Please carry on, sir.
Okay. As many countries keenly followed the proceedings, it sent a signal of political stability and maturing of our democracy, which is good and healthy for Ghana. This also boosts investor confidence. Ghana still remains a destination for investors since it remains politically stable. Definitely, one would prefer to do business in a politically stable and peaceful country. Now let me turn on to the electoral. The televised court process has opened the electoral process to the Ghanaian people once more. Ghanaians now have a better understanding of how elections are run in the country. The CI 127, which is the legal document used for the 2020 elections, is also now known to the public. The introduction of the Regional Collation Center also led to enhancing transparency and openness of the elections at the regional levels. Political parties are a major stakeholders in Ghana's electoral process. The entire process of trial opened the eyes of key political process players to the process. Through cross-examination, certain things were made known, such as training of agents who work on behalf of political parties on election day. It emerged that 4 agents were accredited to work in the National Collation Center, 2 were allowed to work in the center at a time, while 2 remain on standby. It therefore cannot be the case that at any particular point in time, there are no agents at the National Collation Center working on behalf of a political party. Political parties should continuously train and deploy competent people to serve in their interests as polling agents. It will also be a lesson for the Electoral Commission, political parties, and major stakeholders to correct certain mistakes made during the 2020 general elections. The EC must train and retrain its permanent and temporary staff on electoral issues and systems. This will therefore lead to an improvement in the entire electoral system, thereby making the next elections better than the previous. Legal. Societies are held together by law that govern them. Any society will not be able to thrive in the absence of laws that govern them, because chaos and anarchy have never built any society. On the legal front, the confidence reposed in the Supreme Court is even more strengthened. In years to come, one can be rest assured that once an election petition is brought before the Supreme Court, it will be dealt with in a fair and transparent and timeous manner. In 2012 and 2013, the petition hearing, both opposition leaders and the president-elect had confidence in the legal system. The NDC didn't have a problem filing their petition in 2020 because they knew they would receive justice as they did in 2012. The Supreme Court, apart from its adjudication functions, also serves as a forum for policy formulation. The Supreme Court only issues directives. The Supreme Court could issue directives for the Electoral Commission to undertake certain important actions. Hence, the use of court processes enabled the Supreme Court to validate the existing electoral laws, identify gaps, if any, and call for reforms where necessary. Ghana's 2020 elections legal framework emanated from different authorities, including domestic and international, that is ECOWAS and AU. as well as from Ghana's constitution. Indeed, the 1992 constitution in Article 51 states that the Electoral Commission, by constitutional instrument, shall make regulations for the effective performance of its function under this constitution or any other law, and in particular for the registration of voters, the conduct of public elections and referenda, including provisions for voting by proxy. In the light of the Public Election Regulation 2020, CI 127 was gazetted on 2nd July 2020 to regulate December 7 elections. It took its root from Article 51 of the Constitution and received approval from Parliament. These were affirmed by the Supreme Court as valid. In order to invoke the remedy of judicial annulment of the presidential election, there must be clear constitutional and statutory violations of laws governing the election. The petitioner must adduce sufficient evidence to build a strong case in order to invoke reliefs that the petitioner himself seeks, without relying on the evidence of respondents to advance his case. Administrative errors, insufficiencies, and arithmetic false pass without more cannot annul presidential election. Any errors complained about must have mathematical effect on the overall tally of the votes for a rerun to be effected. The Supreme Court, through its judgment, therefore gave official approval to the declaration made .
So viewers and listeners, we have just been listening to Mr. Peter McMenu of the NPP celebrating Ghana's political system as a contest of ideas and the fact that disputes can be resolved and were resolved peacefully. He's also made some specific recommendations for the Electoral Commission and also to the political parties by way of the robust systems that they need to put in place to be able to administer some of the electoral systems. And finally, he's been delving into the legal systems and celebrating the process, thinking basically that the ruling will be one that would show up confidence in the system, and also calling for greater evidence by anybody that wants to present a petition before the Supreme Court. Given the outline, my understanding is that this would be the closing remarks. So I would want us to then transition to the second keynote speaker. And to introduce the second keynote speaker, we have a private legal practitioner, Matilda Aiden Donko. Good to see you, Matilda. And the interesting thing is that Matilda is a former student of Dr. Kumbo. Dr. Kumbo taught her taxation. She's currently a senior associate at Rindolph Chambers with over 10 years experience under her belt as a lawyer. So before you introduce Dr. Kumbo, Matilda, let me just find out, was there anything about the Supreme Court ruling that surprised you, or the entire process that surprised you? You're muted at the moment.
So there were a few things that surprised me, but let me just speak about one. The order by the Supreme Court for the petitioner to file his witness statement within 24 hours. That surprised me because the filing of witness statements was introduced in 2014 with the amendment to the High Court Civil Procedure Rules 2004, CI 47. This amendment, which was introduced by CI 87, does not prescribe the period within which you should file your witness statement. So usually when you go to court at the application for direction stage, the judge is going to give you a time period within which to file your witness statement. And if you thought that the period prescribed or ordered by the court was insufficient, you could ask the court to extend the time for you, especially taking into consideration perhaps how complex the case is. And I have not handled an election petition before, but I do know that it's not a simple task. So to be required to file your witness statement within 24 hours, I mean, I'm being mindful of the duration of time that the Supreme Court had to determine the whole petition, but it is no, I was shocked, because in the simplest of cases, it takes me much longer than 24 hours to file a witness statement. So that shocked me.
I can imagine, I can actually see the shock on your face. And I suppose the Supreme Court had given some very brutal timelines to operate by.
Right.
Hopefully, Dr. Kumbo, your former lecturer, would get to address some of these issues in an address. So could you kindly proceed to introduce him?
Very well. So I'm honored to introduce to you this evening, Dr. Benjamin Kumbo. Dr. Benjamin Kumbo had his secondary school education at Nandom Secondary School. After completion of his secondary education, he proceeded to the University of Ghana to obtain his LLB. Following the acquisition of his LLB at University of Ghana, he proceeded to University of Warwick in the UK as a Chevening scholar to obtain his LLM with distinction. He continued with his doctorate after his LLM, I beg your pardon, at the University of Warwick. After finishing his LLM, he stayed on as a teaching assistant at the University of Warwick. In terms of the academia, he taught the law of taxation at the Ghana School of Law. That is where he was my lecturer. And perhaps I should share what distinguished him from other lecturers in maybe 2 lines. He was very practical in his approach to teaching taxation. Taxation is a difficult subject, but he was very practical. And that I find in practice to be very important, because when clients come to you, it's not about the theory. It's about how you apply the law of taxation to their peculiar issues. And I think he did that very well in the way he taught us. Apart from teaching the law of taxation, I mean, after teaching the law of taxation in the Ghana School of Law, he served in 5 ministerial positions under 2 presidents, which is, I mean, there are very few people with such achievements. He was at a point in time the Minister for Defense. He became the Minister of Health, Interior, Parliamentary Affairs, and Attorney General and Minister for Justice. In terms of authorship, I know that he has at least 2 books under his belt. One of them I have, which he happily autographed for me. It's The Law of Taxation, and he co-authored another book on taxation with Mr. Ali Nachia. Currently, he's working on a new book, and the title of the book is A Practical Guide to Witness Statements in Ghana. Mr. Kumbo is happily married and has 3 children. He also currently lectures at the University of Ghana School of Law. He left at a point in time, and I believe he's back lecturing at the University of Ghana. Ladies and gentlemen, help me to welcome Dr. Benjamin Kumbo, our second keynote speaker.
So Dr. Kumbo, over to you. Dr. Kumbo, if you're speaking, you're currently muted, so we can't hear you.
Can you get me now?
Excellent, excellent, we can.
Okay. So we will go straight and begin to address a number of the more fundamental issues that relate to this particular matter. But firstly, let me indicate that my good friend McMenu did indicate the significance of the rule of law. Hello, can you hear me?
Yes, we can hear you loud and clear.
Yes, but the rule of law has developed over the years, and it now means not one thing, but many, many things. And one of the essential features of the rule of law is the certainty of the law. And that is what brings me to my first issue. If you look at the rules of court committee and what they have done in relation to the rules that govern civil procedure in the country and those that specifically govern the special jurisdiction of the Supreme Court on presidential election petitions, you would find that there is a major, major challenge. If you take CI 47, the first order is that the whole idea about revising the civil procedure rules is to ensure speedy and effective justice. These two words are important and they cannot be disconnected. Speedy, yes, but that speed must lead to effective justice. That is how we need to read it. And Justice Sophia Akufo did amplify exactly what this particular order means. It says to talk about speedy and effective justice, you are talking about creating a situation of certainty, predictability, but more importantly, transparency in the process. And this is a decision of the Supreme Court. So in fashioning out any rules of procedure, you must also be dealing with the issue of how those rules will not achieve only speed, but it will also achieve effective justice. And this is very, very significant. Now, if you look at the timetable, which started with CI 74 and was amplified and abridged in CI 99, you would see that the tenure of those constitutional instruments was focused on the speed, but not the effectiveness of the justice. And that has a bearing on how this case traveled and how it ended. But let me indicate also from the onset that one of the things we need to look at is the applicable rules, so that all the parties are certain in their mind that this will be the applicable rule. And that for me is one of the first lessons that we need to learn. But let's go back and deal with how the issues were handled. And let me add a caveat that until one has a complete record of the proceedings, you will have a challenge in relation to how the court arrived at a number of positions. And so with that caveat, we move on and begin to see how these issues were dealt with. Quite often in big cases of this nature, you will try as much as possible to see how you can marry the issues as filed by both parties and make sure that the deviation between the two is not too wide. After all, they have brought the matter to court. The pleadings are set there. But when the court indicates that they are beginning to deal with the real issues as the court considers arising from the pleadings, then we have a challenge. The record of proceedings will tell you the nature of the reliefs that were sought and the issues that the petitioner considered to be the germane issues and what the respondents considered to be germane issues. So the lesson you learn now is that from the ruling of the Supreme Court can recast the issues and determine them by its powers of discretion that based on our understanding of this matter, we think these are the real issues. You can get away with some of those things in very trivial matters, but in weighty cases like this, we need to be very careful because the determination of the tribal issues invariably determines the outcome in a particular direction. And if you watch the issues that were raised by the Supreme Court as the real issues, you see clearly that the evidential burden was very, very heavy on the petitioners. And this was based on the premises that we were going to go into the issue that, well, you win your case by the strength of your case and not on the weakness of your opponent's case, which has been tried learning for all lawyers of procedure. But you see, laws hand and rules hand in hand. The same proposition has been made that as much as possible in determining tribal issues, you must make sure that the merits of the case are dealt with. And by merits, they are not talking of the merit of who has a weaker case or who has a stronger case, but that both sides should be heard, the evidence taken and evaluated so that you know you are now dealing with the merits. And that is one of the first issues that we have on the nature of the issues that we raised. The second one are the applicable rules of procedure. If you read Order 47, from which a subsequent amendments took place, Order CI 47, is very clear that those rules are applied to procedure in the High Court and the Circuit Court. And even in the case of the Circuit Court, it must be with modifications. The word that was used is shall apply. So it didn't leave any room for those rules to apply to any other jurisdiction or any other court. Now, if you find out what happened, the court decided that it was going to adopt the rules dealing with witness statements in CI 47 to ensure that an order that witness statement should be filed. I have some challenge with this, whether the Supreme Court is capable of doing that. There must be good reason for it, but whether there's legal authority for that. This is because when you go to the specific, you must distinguish CI 47 as a generic procedure for the High Court and Circuit Court. And you would find that the Rules of Court Committee have also prescribed rules for the Supreme Court in terms of its original jurisdiction, its appellate jurisdiction, and its special jurisdiction in relation to presidential election petitions. And if you look at Rule 6 of the Supreme Court rules, it says specifically that where in determining a matter, rules of procedure that do not exist, the Supreme Court is to prescribe rules of procedure. It didn't say it must adopt rules of procedure. And if you look at what the prescription that is anticipated requires a formal pronouncement, one that is authoritative, one that states that we think that we don't have rules for A, B, C, D. We are now going to ensure that for this particular purpose, these are the rules we are prescribing, but not to adopt High Court and Circuit Court civil procedure rules without giving the legal justification for that adoption. That aside, if you go and look at Order 70 of the Supreme Court rules, it has prescribed rules for presidential election petitions. It says a party can apply for witnesses to be called in relation to evidence, or the court can, on its own motion, require that witnesses are called. And this means that in relation to evidence, the rules have been set out there. So if you were required to prescribe rules and you did not prescribe them, CI 47, the CI 16 doesn't give you the legal authority to adopt rules. And if you look at the law dictionary's definition, you see a sharp distinction between what it amounts to adopt something and what it amounts to a statute. And that becomes an issue. Then if you read the court judgment, there was a particular point in which the court says it wanted to send a word of caution to parties that adopt rules in CI 47 without asking or making an application for say. And this was in relation to Order 23, when the petitioner sought to file for interrogatories and admissions. It says that there was no application and that those were rules for another court. And you could not, without the leave of the court, just bring them on board. And this looks strange. If a procedure is adopted under CI 47, is that procedure only available to the courts? It's not available to the parties. And that for me was what was challenging. If you look at CI 74 and CI 99, that amended CI 60, there is no mention there about amending or changing CI 23. Which Order 23, which will require that you cannot allow admissions, applications to be filed or interrogatories to be filed. There is nothing in CI 99 that prevents a party from relying on civil procedure rules that the court itself adopted.
Doug.
Now, because we don't have the record of proceedings, I must say, we do not know the context in which that adoption was done. And that for me is very, very significant, and we need to look at a number of these procedural issues that we have to deal with.
Doug, sorry to interrupt. There are a few requests coming in. If we could give your video a chance. So maybe let's try and see whether we can sustain your video.
Okay.
And then, yes.
So can you get me on?
Yeah, you may have to switch it on from your end.
Really?
Yes.
Okay.
Yes, we can see you.
Okay. Yeah, but I'm not seeing the pictures.
But can you go on with your presentation?
Yes.
All right.
Sorry, Doc, what pictures? Is it your screen?
Yes, on my screen, because we're asked to minimize the, what do you call it? The screen.
It's because of the settings. I think you are probably focusing on the speaker, and because you're the speaker, that would be it. But we can see you, so I think that's fine.
Okay, because even you, I can't see your picture. That's the
So the settings are made in such a way that it's only the presenter who will be on the screen until there is an interruption from any of the hosts or any one of the participants is allowed to speak.
There is this post attendee Zoom. Should that be the one to be highlighted?
No, Doc, you can go on with your presentation, please.
Yes,
Okay.
Please go on.
All right. So that is the second issue that we need to look at very, very clearly in relation to this matter. But you see, you will not be able to get the full import of the final judgment on 4th of March if you do not relate it back to the ruling that was given on the 11th of February. The Supreme Court cited a number of authorities which went to buttress the point that a witness cannot be compelled, which is in the CI, 87, Rule 3, E5. And that it cited a number of authorities to show that that is the legal position, and the court had no way of compelling a witness that had filed a witness statement to take the witness stand and be cross-examined. Now, it is indeed the law, but the context of the authorities that were cited is what raises a number of the challenges. To cite Olenu a case that was decided in 1962 is distinguishable under completely different civil procedure rules. I will not see how relevant Olenu's decision in 1962 would be in relation to a situation in which witness statement has become the reality of our procedure. And I'm making this statement because I noticed that the Supreme Court distinguished the Sumaila BLBL case on legal grounds. And it also shows that in distinguishing cases, the Olenu case will be appropriate. All the other Supreme Court cases that were cited to buttress that point, most of them, if you watch, were dealing with appellate jurisdiction of the court and not the special jurisdiction on election, which provides a basis for distinguishing them as well. Because if you look at the appellate jurisdiction, you'll find that the issue of evidence only comes up because it was one of the grounds of appeal. And so when that ground of appeal has come up, the court will have to address it as a ground, accept or dismiss it. So when you are dealing with that type of case that came from an appellate jurisdiction of the court, with what is a special original jurisdiction of the Supreme Court on presidential election petition, you have a challenge there. The most disturbing one was the Lloyd's case. And I happen to have been in the UK at the time the Lloyd's case came up. We're using it as one of our case studies to teach our students. And there is something very unique about the Lloyd's case that people need to look at, and its context. If you look at the wording of the UK civil procedure rules under which the Lloyd's case was decided, you see clearly that it is provided in those rules that if a witness doesn't intend to give evidence at the trial, that witness must give prompt notice to the other party for that other party to decide to take advantage of the same rule that was used in CI 87 3E5. And that prompt notice would have allowed the other party to actually put that evidence in as hearsay, and that would have given them an opportunity to address on that evidence. So if you are not looking at the specific wording of a decision like Lloyd's case that was based on civil procedure rules in the UK that are slightly differently worded from Ghana's CI 87, it is another ground to have distinguished Lloyd's case, and that is inapplicable. The mere fact that witness statements was at issue in the Lloyd's case doesn't make that the ratio of the case. The ratio of that case was on the latitude of the civil procedure rules 32.5. And so when you take all these issues together, you have a challenge as to how BLBL could actually be distinguished in the context that if Justice Dateba at that time
How can we understand?
insisted that the witness ought to be cross-examined because of the affidavit that was filed. And the Supreme Court in this present case made a distinction that in that case, there was what you call an affidavit that was filed. And so that constituted evidence. And in this particular case, there was no issue of evidence that would have led to that. That again creates a major, major challenge. Because for all practical purposes, there are various forms in which evidence is taken. And this particularly comes in the context of what somebody might say. The petitioner might have misled the others, the respondents must have misled the other side and the court as well. Particularly when you depose to an affidavit, which was sustained, that the questions and interrogatory admission and things you wanted made in the application could be handled under cross-examination. Only for the petitioners to close their case, all the doors were shut against them. And when it was time to open your case, you then indicate that you do not intend to give evidence, which makes it very difficult when we are talking of handling a case on the merits, which makes it difficult for the petitioners to be able to handle that. And if you watch the nature of this case closely, the absence of evidence from the respondents, they use cross-examination as a tool to elicit evidence that the Supreme Court relied heavily on. And that opportunity was not given to the petitioners because what information they were looking for, which they claimed was not provided, and that the burden was not discharged by the nature of the evidence that they gave. Is it not certainly the case that cross-examination would have brought out that evidence? Because you are dealing with a constitutional office, and you are dealing with a person that is designated in the law to perform a particular role as returning officer. So the best evidence in relation to those matters can only come from that source. That is not to indicate that the petitioners couldn't have brought their own evidence, as it were. But if you watch the nature of the pleadings and the strategy of the petitioner's case, you'll see that there was a lot of caution not to tread that particular path. Now, when you come to the particular interpretation, whether anybody actually crossed the threshold of 50+1, there is a challenge there. Let's be very clear, the petitioners had made the assertion that they did not think that was the case. And the evidence that they gave was to the effect that there was a first announcement or declaration of the results. It is still highly contested whether there was the first procedural step that was taken, collation, in the presence of agents before the declaration was made. That issue still remains open. Now, immediately you collate the results and announce it. You give it legal validity by a constitutional instrument. And that constitutional instrument was CI 127. It is that constitutional instrument that gives legitimacy to declaration of results. Then the next day, knowing the procedure too well, you come to say there were some mistakes. And the mistakes was corrected, this time not by amending the constitutional instrument 127, but actually through a press statement. This is not just a mere irregularity. If there is a constitutional procedure for how valid results are declared, and that procedure involves subsidiary legislation, a press release, unsigned as it is, cannot be a substitute for a constitutional instrument. That is the crux of that matter. So yes, even assuming without conceding that the correction was actually made, was that correction declared as required by the Constitution, by a constitutional instrument? What you needed to handle was actually an amendment of CI 127, which was not done. So the only valid results that were declared by the constitutionally required procedure was what was attached to CI 127, which even the respondents themselves admitted the figures were wrong. And that was what gave legitimacy, actually, for the petitioners to say that by the declaration, they didn't say by the press statement, they said by the declaration in CI 127. And the figures in that declaration show that nobody crossed that threshold. That is the issue. And that, for me, is the tribal issue that we have looked at. Be as it may, people don't still remember that there was a third correction again that was made. And that third correction led to the absurd situation in which if you put all the results together, which should cancel out as 100%, you had a situation that those figures led to a 103%. And there was no explanation. Then come the figure that the court actually relied on. And we are wondering, those figures that the court relied on the decision, where did they come from? Through cross-examination. Was the cross-examination the one that declared the results? Should you take questions people answer in cross-examination as the equivalent of actually declaring results and through a constitutional instrument? These are, for me, very, very weighty issues that we need to look at in relation to this election petition. And we can yet go to another important thing about the issue that was dealt with in relation to the pleadings. Because again, one doesn't have the record of proceedings. If you read the court judgment, you will come across situation in which the court at one point is referring to the pleadings, one of the parties, and referring to evidence as well. And you don't get it very clear in the judgment whether reference is made to the pleadings of the respondents or to the pleadings of the petitioner and to the evidence of the respondents or the evidence of the petitioner. That, if you read the judgment very closely, you never get a clear idea on exactly what was there. And the question I'm asking, was there at any point in the record of proceedings that the file witness statements by the respondents, which they did not go onto the witness box to tender, and for that matter, it was not evident, was it expunged by the court from the record? And I'm saying this for the reason that we have known time and time again that there's always what you call the unarticulated premise. Once you have documents on the record, the court, to be fair to them, never alluded to any evidence whatsoever of the respondents beyond what they got out of cross-examination. And so we need to get it very clear on the findings of fact that the court made, what evidence it was based on. In the judgment, I've seen excerpts of cross-examination and I've seen answers and how those answers have been used. But that creates an issue for us to interrogate by looking at the record of proceedings and to see what happened at what particular stage. There was another position that was taken by the court that indicated that when you bring a matter under Article 23 of the Constitution. Are you hearing me? Can you hear me?
Yes, we are. We will mute. Somebody was unmuted, but we will do it from here. Please continue. Sorry.
Yes, yes. And they indicated at the end of the day that you cannot bring a matter under Chapter 5, the Human Rights Commission, to the Supreme Court. And that the proper avenue for that cited a number of decided cases. And there was a big legal issue that was raised, which the Supreme Court should have used the opportunity to clarify. In not 1, 2, 3, 4, 5 decisions of the Supreme Court, the Supreme Court has clearly indicated that when you are looking at the special jurisdiction on human rights that is given to the Supreme Court, you must be looking at it from the perspective of enforcing the human rights provisions. But where a human rights provision becomes a matter of interpretation, then the only court that has that jurisdiction is the Supreme Court. Now, if you see the pleadings and the nature of the evidence that was being led, you will see clearly that they were asking for a declaration that on a proper interpretation of Article 23, the conduct of the first respondent was not fair, it was not candid, in relation to evidence that the court described as fanciful. Now, if you had tested the fact that this was an issue for interpretation and not enforcement of a human rights provision, perhaps the scenario would have been different. And that, for me, we need to take a second look at it so that we become clear in our mind that the law is certain and we have an idea where the Supreme Court actually stands on whether the mere fact that you have brought Article 23 to the Supreme Court, you are coming to enforce Article 23. You might just be coming for an interpretation of that article in relation to the specific conduct that is already in evidence. And I think we need to look at that issue again very, very closely. Then you come to the issue of the presumptions. And that was very interesting. You know, presumptions are the ones that when preliminary facts are established, you do not go to the whole length of using evidence to establish those facts for the courts to adopt them. The preliminary facts will immediately trigger either an absolute presumption, one that is not rebuttable, or a rebuttable presumption. Now, if you look at the presumptions that were used on the regularity of the constitutional instrument 127, with the greatest respect to their lordship, I have a challenge with that presumption. Because the very thing that the petition was challenging was the regularity. And the regularity is that the figures did not tally up to 50 plus 1. And that was enough evidence to rebut the presumption of regularity. Once the court itself accepts that mistakes were made and corrected, you don't just dismiss mistakes as having been made and corrected. The question you need to ask, are those mistakes of a clerical or typographical nature that one can say the presumption of regularity of substance as against form should be followed? Here you are dealing with the substance of the figures. And if those figures are agreed in the declaration by CI 127 are not accurate and do not tally up, then it shows clearly that Article 63(3) of the Constitution has been breached. There is no way any other form of declaration outside the prescribed constitutional procedure can suffice. And there is no way we can treat those corrections or errors, which the court itself acknowledged, as trivial, that can just be corrected in any other manner, and not through the laid down procedure, through a redeclaration, if I would use that term. And the redeclaration at that time would have also had the real corrected figures again. And those corrected figures again didn't add up, because that was the one that led to the over 100% when you try to total and cancel out to get your 100%. You always had more than 100%. So it meant that the excess of the 100% is a very substantial issue. And I believe, all said and done, this is the more reason why the weightiness, the ambivalence, and the ambiguity in this case would have suggested that let the returning officer take the witness box and clarify these issues for us. This is what would have left nobody in any doubt. That, look, we are now telling you that this is exactly what happened, and this is what we did. This was where the error came from. As we sit down now, I do not know whether somebody else did the coalition or the returning officer did the coalition. Because the coalition has to be done by the Electoral Commissioner. It does not give any room for delegation of that coalition. And that is why a declaration that came by an unsigned press release, which has no attributable source beyond the Electoral Commission, it cannot be presumed that that came from the returning officer in the presidential elections. And this, for me, is a very, very significant issue that we need to deal with. Now, when this takes us back to a number of very, very fundamental issues. You see, all these constitutional instruments we have been dealing with are subsidiary legislation. And there is no way a subsidiary legislation can defeat an act of parliament. We have our hierarchy of laws. We would have expected to find out what does the evidence decree say in terms of the forms, the ways, the nature, and extent of evidence that can be taken. The evidence decree certainly provides a number of rules to deal with some of these situations. What does the Courts Act say in relation to evidence? And when you take all these substantive legal rules, you would see that they always provide a leverage in which where a witness will not give evidence, they would want to have some form of evidence that the court can rely on. And that's why when you see all the cases that were cited, and I take an issue that they should have been distinguished, in most of the cases, particularly at the level of the trial court that came on appeal, there was always alternative evidence, either of an expert witness that was already on the record, or one that was affidavit evidence that was already there to guide the court. And what prevented the court, assuming we wanted to deal with this case on its merits and settle all the issues, lay down the appropriate precedents for the future? I think the best procedural rule for the Supreme Court to have adopted would have been Rule 70 of CI 16. Either an application will be made to call evidence by a party, or the court can, on its own motion, based on the justice of the case, decide that we think that witnesses should be called in this matter and possibly subjected to cross-examination. This would have left no doubt, as we sit now, the cloud that we have for both lawyers and the lay people, the procedural right to opt to be unavailable as a witness. Yes, that's the position of the law. But is that the way to go in a petition of this magnitude and constitutional significance? You don't leave anything to doubt and anything to chance. So to go and adopt CI 47 on witness statements, only for the petitioner to believe that with this, we are capable of using other procedure to elicit evidence based on the CI 47 and the CI 23 by making the case faster and narrowing the issue by asking for some admissions to be made based on the witness statements that were filed in pleadings, and also making some interrogate and asking some specific questions, the answers of which would have been in evidence, and this will not be a matter of controversy. That opportunity was missed again because we were looking at the speed aspect of our rules of procedure and not the effective justice of transparency, predictability, and certainty that we were expecting. And that is why these rules, we need to be very careful. So why CI 16 Rule 70 did not arise in relation to this matter still beats my imagination. When I indicated at first that the Supreme Court under Rule 6 of the Supreme Court rule is required to prescribe rules and not to adopt rules that are meant for the High Court and then the Circuit Court, even with some modifications. We have another major lesson to actually learn from this. That if you really take the import of the Supreme Court ruling, no lawyer can take it for granted that the tool of cross-examination, which is such a powerful tool to elicit evidence and use it to also present your side of the case, would always be available as a matter of right. And this presents a very changed scenario because the central place of cross-examination in our legal forensics is well known. And that for me is significant, and a policy of staying with the position of the procedural law without having regard to the substantive law issues, we have a problem. In fact, if I were asked, I'll say CI 99 is unconstitutional because as a law that is passed by the Parliament of Ghana, despite the fact that the rules were prepared by the rules of court, there have been the Apalu case where they said that, look, if a statutory instrument is not laid before Parliament or constitutional instrument, it will not have the force of law. So we see CI 99 as a law for all intents and purposes. Now, you have had accrued rights, constitutional rights, to a fair trial in your constitution. So every litigant that goes to court is actually going with the idea that he will have an opportunity to present his case. And the opportunity is not just only his side of the case, but the legal armory that he can use, which includes cross-examination, to present his case. If the ability to use that legal tool of cross-examination is truncated because of speed, and you could not have had it through interlocutory applications, and you cannot even have it through a substantive situation of cross-examination where a witness takes the box, you cannot say that the trial has been fair in this particular case. And when I talk about fairness here, I'm talking of mutuality. If you see the extent to which the respondents made use of cross-examination, that alone should have said, look, we are the Supreme Court and we are deciding that based on Rule 70, we would want the respondent's witness to take the witness box and tender their statement. Let's now match that evidence against whatever you might call the defective evidence of the petitioner. Then you are now looking at the case on its merits, and fairness has been given to both sides. But if one side has been able to use the legal arsenal to advantage, and the other side seems precluded from using the same arsenal, then you have a major issue that we have to deal with. And I'm saying this on the strength of the pronouncement by Justice Sophia Akufu, who indicated how important this clause of civil procedure rules achieving speedy and effective justices. So you don't disaggregate the speed from the effectiveness of the two are conjoined, and you cannot handle one without the other. But I would say the constitutionality of even CI 99 is in question as a subsidiary legislation, and we need to take a second look at it. Of course, we can understand what happened in the 2013 petition, the length of time that it took. But at the end of the day, the issues became clearer for everybody to see. In this particular case, speed took the center stage. And because of the nature of the speech, we sacrificed a number of proceedings. We sacrificed a number of appropriate legal steps that the petitioners would have taken. And it is, again, the courts that tell us that at the end of the day, justice must be seen not to be done, but to be manifestly done. So speed can lead to a form of justice. But as to whether that justice has been manifested can only come through the second leg of that rule, that it must be effective. And that, for me, is a very important issue. There are so many issues that one can look at.
Yes,
But when we come to a number of the issues that my friend Menu raised, there remain a number of questions. Yes, the political question as to not calling the president to congratulate him as was done in 2013. You see, you must be looking at the scenarios slightly differently. The presidential candidate of the NDC happens to come from a political party in which a number of outstanding issues during the elections have not been resolved. You would know the number of people who died through gunshot wounds in this particular one. And so you are still having to deal with a party that is still licking the wounds of this loss that it has had. You are also looking at the immediate runoff to the sessional address that the president gives. I am just making my conjectures, and I have not even ruled out the possibility that the petitioner would definitely, as a matter of course, call to congratulate the president. If it was done in 2018, immediately, the context is different. It could still be done now, but the timing did not coincide or be exactly as it happened. So yes, one will expect that it is a show of statesmanship that would be done. And as talking for myself and not for the party, I believe there's all the likelihood that that would be done. So it is not one in which there is an unwillingness or intransigence from the petitioner to conduct himself in an unstate manner. Then when you are talking of the confidence in the system, I do not know. Then perhaps we've been talking to too many different lawyers internationally who have been looking and following at this case. We also have a number of the bar and also some legal luminaries in other jurisdictions that have been worried about the inability to get accountability from an officer that is constitutionally given powers to perform a function. When the preamble to Ghana's constitution has probity and accountability as a spirit, even if the letter of any law at all permits accountability not to take place, the spirit of the constitution in terms of accountability and probity is enough to have been invoked by the court so that the respondent witnesses could have taken the witness box in relation to this matter. So it is now no more whether you have a procedural right to mount the witness box or not. It becomes a constitutional responsibility to stand up to the standard of accountability, which is the mark of good governance. So in all these things we are looking at, the issue of good governance becomes very, very important. And you cannot have good governance without accountability in its vertical and horizontal context. If I were the returning officer, I would rise up to that occasion, take the witness box as my accountability to the people of Ghana. Remember, the courts are handling their justice in accordance with law. But the Constitution says no. Your justice according to law is there. But justice emanates from the people of Ghana. And the courts are the ones that actually dispense that justice on behalf of the people. So you must have the people at the back of your mind when you are actually dispensing justice according to law. I'm not even talking of dispensing justice in its moral and ethical context. Justice according to law rests eventually with what the Constitution enjoins us to do. And that is, for me, very, very important. The audience that watch this case are not all lawyers. And so you keep hearing the lawyers' perspectives and you keep hearing the non-lawyers' perspectives. Unfortunately, like most Supreme Court judges, I have had personal discussions, and the Supreme Court has said so in so many ways, that the Constitution is a special document. There are a number of Supreme Court decisions, starting even from the 1979 Constitution, on the special nature of the Constitution. And that is why simple rules of procedure And even, I'm sure, legislation cannot be transposed to the basis of interpreting such a special document. That is why my worry for the resort and religious adherence to constitutional instruments as against the substantive issues can be very, very worrying. And I think if we are looking at our rule of law as one that has to really work, we must go back and see beyond the Delhi and Athens Juries Committee. We have moved the rule of law into all sorts of areas, which now includes issues of human rights, and particularly economic, social, and cultural rights. So let's not be looking at the rule of law in only its generic form as we have learned it in the classroom, but the developments that have taken place in relation to the concept, if you apply it to this case, you would find that most of it would be wanted. The transparency element of it, the certainty of the applicable law when these matters come, the predictability of what the court will do, all these issues come into play as issues of the rule. Yes, one would not say we are not following the rule of law, but because the rule of law is not wanting, if you have a box that has all sorts of things in it, if you pick one piece out of that box, don't assume that everything in that box has been picked up. Do a complete assessment and make a distinction between the individual trees and the woods. Don't be talking the concept rule of law is the woods, but the individual trees that make up the concept of the rule of law needs to be appreciated and articulated. And I think that is very.
So, Doc, it would be good for us to be wrapping up as the time is fast spent, but we could listen to you forever. It's fascinating, but it would be good if we can now begin to close the curtain. When you are done, I would just ask a couple of questions to you and a couple to Mr. McMenu, and then we close.
Yes. So when we keep talking about the Supreme Court determined that based on the results, the constitutional requirement of Article 63(3) have been met. Which results are we talking about? The article just doesn't talk of any results, that anybody can jump onto the rooftop and announce results, that a clerk in the Electoral Commission can post results. We are here talking about results that are properly collated with agents and declared by a constitutional instrument. So I want to know the results that cross this threshold of 50.1% with all the in relation to the correction. What is that the type of results that Article 63 clause 3 require? That certainly is not the case. And we are saying that as long as CI 127 stands, that is the law until it is otherwise changed. And there is no amendment to CI 127. So for all legal intents and purposes, the figures in CI 127 represents the results that were validly and legally declared by the first respondent. This is the core issue, and that is what has given rise to all the other release that has been asked. Yes, I think I'll leave it here and I can fill in some when questions come up.
Thanks a lot. Thanks a lot. That was a real tour de force, raising a number of contentious issues that CI 99 was unconstitutional. You have asserted that the trial was not fair, and in fact, speed was sacrificed for effectiveness. Fairness was sacrificed for speed. And then also that, the inability of Madam Jean Mensah to mount the stand did not do justice to the case, leaving a certain cloud behind. And I think that also aligns very strongly with the NDC's argument, in that the NDC says that the declaration of the 9th was the only declaration, valid declaration, and you have tied it very strongly to CI 127. and also raised questions about the processes leading to the declaration of the results. And because of that position, I think the party, the NDC party, did not find it necessary to make what I consider the mathematical argument in terms of adducing evidence from its own collation to prove that the presidential candidate of the MPP did not cross the 50% plus one threshold. My specific question to you is, how injurious to the NDC's case was the inability and or refusal to bring its own figures to court?
Yes, that's why I indicated that if you look at the nature of the relief that was sought, it was clear from the pleadings. What we need to go back is that, what was the answer of the respondents to that pleading? You see, if I indicate that in my pleading that nobody had actually crossed the 50 plus one, and you believe that that was indeed the case, you will indicate quite clearly, you can traverse it and state facts that would show, and follow that up in your witness statement. So you see, when a lawyer is conducting his case, he's dealing with also the strategic elements. For instance, if you take the issues of matters of law and interpretation that will come up, there was no way the respondents would have weighed into the issue that bringing Article 23 to the Supreme Court was inappropriate. You see, because this was based on what? Case law. And the Supreme Court has said that in a number of cases. But to put it to rest, the Supreme Court would have gone further to say that, except you were coming for an interpretation, because you don't just assume that they were asking you to enforce. They say make a declaration. And in declaratory judgments, you must do an interpretation. So I didn't think the petitioners really came for you to enforce Article 23. Just as they didn't come there to come and say that as far as we are concerned, it is not the responsibility of the petitioner to collate results. That is the first point. That is a constitutional duty for the respondent, first respondent. It is not the duty of the petitioners to declare results. So that will be for the respondent. So for instance, if I were to go to court and there is no duty imposed on me, why will I jump into the fray in performing a duty that is supposed to be performed by the other side? So I simply allege that that duty has not been performed in accordance with law, and let the other side handle it. Come and tell us that you did perform that duty in accordance with law. And then we now go and look at what is the law. What does the law say? You collate and you declare. And the declaration is not by word of mouth. It must be followed by a constitutional instrument. That is the position of the law. That's what the Constitution says. So I do not think it is a matter for the petitioner to be dabbling in mathematics, particularly when you are talking of the sources and custody of evidence. Because if it were to even attempt introducing this evidence in its witness statement and then also in its pleadings, it could be struck out as they not having that mandate to do that, or it could be considered as hearsay and excluded. Because they are not, the petitioners are not the custodians. They are not the appropriate legal source for results that are validly declared. So why should that obligation and burden be put on them? That's why I said that this is one of the cases that we should have seen that, yes, the burden will initially lie with the petitioner, but as the petitioner's case unfolds, there's the possibility that burden can shift to the respondents.
Thank you. Thank you very much for that. My last question to you, I mean, Dr. Kumbo, you are a very well-respected statesman and also an elder of the NDC party. If you were to advise the NDC, what would that be? How does the NDC pick up the pieces, move forward as a united and strong party? What would your advice be?
Well, basically, this is a procedure, and the NDC has also displayed, as my friend McMenu indicated. The NDC also went to court. They didn't go to the bush. They didn't take up arms. So it means the NDC itself is prepared to play by the democratic rules of engagement. But while playing by those rules of engagement, it is also at liberty to indicate some democratic deficits. And we do know that in the African continent, we are beginning to witness a wave of democratic dividends after the euphoria of the post-1990s constitutional expectations of people. And that is why if you watch our democratic credentials, it is only at the level of elections. And electoral democracy is not the only essential elements of democracy. That we become democratic or follow democratic processes to elect our leaders. And after that, we must go through undemocratic practices till the next election. We must begin to transcend electoral democracy into more substantive issues of democracy: respect for human rights, respect for due process, equality before the law, all these other basic values of democracy. The inability not to abuse incumbency, which seems to be a fashion now, that once you are in power, there's something you call the winner takes all, a particular phrase I have never been comfortable with, because I thought government was about service and not about takings. So we still have a number of democratic challenges in that particular context. And nobody should delude himself that by simply going through a number of successful elections that have been challenged and the challenges we have come over there, we have arrived. No, we've only put one leg on the first stair of the ladder or the staircase. We have not even lifted the second leg yet. And people need to be very, very, very careful. We must nurture this democracy. We must be seen moving beyond the election. And we must be seen, you see, when people queue in the sun and vote and elect us, they do it out of euphoria and some expectations. That vote they are casting will translate into material improvements in their human condition. And you can see it. If you see the margin by which the NPP won in the 2012 elections and how that margin has shrunk, I think McMenu and co ought to do a proper soul searching and not to give the impression that we are actually riding the high horses of democracy in Ghana. No. If you remain on such a high horse and nobody can bring you down, you will come across a low branch. And I'm beginning to see a lot of low branches as we move ahead in our constitutional dispensation. And I think—
Thank you, that was brilliant. Thank you for connecting us to the core purpose of the democratic governance. And with that, I will transition to Mr. Peter McMenu. Also, just a couple of questions. So, Mr. McMenu, in the build-up to the petition, I know you granted an interview to Joy FM in which you said, if I may quote you, that we believe and will prove in the Supreme Court that even John Mahama did not receive the number of votes that have been credited to him. We are going to show that during the course of the trial. Some say that this proves that President Mahama's case that the 2020 polls were fundamentally flawed is true. Do you sincerely believe, as you asserted in that interview, that the percentages attributed to all the candidates except Nana Akufo-Addo by Mrs. Jimensa were all incorrect?
Well, I think that the election processes of 7 December was never challenged. Right from the distribution of electoral materials, logistics, perfectly done, right to distribution of biometric machines, perfectly done, right to queuing, even under COVID regulations, were all done, despite the scaremongering that was coming from some civil society organizations. It never happened. So I think the Electoral Commission, as far as the rules of the game on the 7th of December was concerned, did perfectly well as far as the conduct of the elections was concerned. But you know that election starts from registration era, pre-election, election, and then D-Day. And when election closes at 5 o'clock, then you start another post-election era, which is the results and results declaration. So for the election itself, I haven't come across anybody. I came across incidents of people, Electoral Commission officials who were tearing ballot paper in the wrong way by tearing Akufo-Addo's head away and giving the ballot paper without Akufo-Addo's picture on it. In faraway Boku, one was accosted and I think he's in jail now or was fined. And one in Central Region. These things did not happen by chance. So I'm saying, and the Electoral Commission acted with dispatch to get these officers.
Yeah, I think Mr. McMenu is having issues with his connection. All right, time is fast spent. It's unfortunate because we had a couple of questions for Mr. McMenu to address, and it looks like his connection will not allow us to delve into it. But we as a center will follow up with him outside of this call, get his feedback on some of those questions, and then publish on our website and also our Facebook page. So I just want to express my own sincere gratitude to Mr. McMenu and Dr. Kumbo. I think this has been fascinating, very rigorous intellectually.
I'm saying, I think I want to finish. I'm saying that
okay.
The election was conducted and executed without any trouble. And the Electoral Commission did marvelously well. And that in spite of the COVID, all procedures were followed. Hello?
Hello?
Hello? Are we on?
Yes, we are.
Yeah, so if I am being interviewed on the day that the NDC presidential candidate submits his petition, and I said, I believe, that's the word I use, I believe that he did not get that number of votes. And I think that the dictionary definition of belief does not bring in an amount of certainty and truth. So it was left for us in the courts to delve in to find out. So you cannot put that on the shoulders of the Electoral Commission of doing a bad job. No, certainly not. Because right from the polling station to the constituency collation centers, to the regional collation centers, up to the national collation center, everybody knew and accepted that the execution of the commission's work on that day was quite perfect. So we cannot use an interview in which the word belief is used to describe the Electoral Commission as being biased or pardon somebody's vote. But let me tell you, it was borne out in court that the evidence that the NDC submitted to us, the second respondent, rather had words padded for NDC, padded for MPP, padded for both MPP and DC. So they rather must explain how it came to light that some numbers had been padded for NDC, MPP, and others, and all of us. But as I said in my presentation, what is the mathematical effect of the alleged padding on the overall results of the election? Dr. Kumbo seems to run away from that, but it's important that if it doesn't have any effect on the overall results of the election, nobody is going to call it a runoff or anything. So whether it's padding, to what extent do that have effect on the general results, mathematical effect on the elections is very critical. And we must look at that on allegations before we proceed.
Thank you. Thank you very much. I have to be fair to you by asking you your second question so that it's balanced. And because you are dwelling on the process, the electoral process, and because of your deep experience, especially as Ghana is concerned, I would take you to the National Collation Center, the so-called strong room. And we picked up reports of somewhat chaotic scenes where fax machines broke down. The EC at some point was not able to access information through fax machines. And this is something I just want to confirm. Are you able to confirm that the fax machines were not working and that the EC officials were bringing in results without verification, as to where they were coming from?
That would be
and
a lazy,
whilst you are
that would be a lazy job on any campaign manager worth a salt to go and sit at a collation center and says results are not coming. Mind you, the Electoral Commission assigned one fax machine to each region. So the 16 regions, each of them had a dedicated fax machine. And this is not the first time that is happening. So you want to tell me that a region like Eastern region or Western region is faxing maybe 4 documents from Sekendi or Koforidua to Accra, and that will jam the fax machine? Is that what you are telling me? That's unbelievable. What's the number or the quantum of documents that are going through the fax? Only about 4 maximum a day, the whole day. And you want to tell me that jammed the fax machine? Unbelievable. It can't be correct. It cannot be correct. Okay? And these were brand new fax machines that have been tested. So, and like I said, it is the onus is also on you as a campaign manager or as a party to also make sure that you get your own para vote tabulation before you even set foot to the collation center, so that you are able to compare. So you don't go and rely on what the Electoral Commission is going to give you from the regions. You have your own set of results, which have been brought to you with speed, accuracy, and timeliness to be able to match what the Electoral Commission is giving up to you. So it did not happen that 16 regions, each with a dedicated fax machine, will get fax machines that are clogged or jammed. I mean, it's unbelievable.
Thanks. I mean, Mr. McMenu showing himself to be an effective political operative, turning the pressure right back onto his opponents. I think this has been very fascinating. So let me hand over to Bashira to Kamal Muslim to properly thank our distinguished speakers and bring us to a close. Bash.
Thank you so much. And I must say that we enjoyed every bit of the session, loaded with a lot of information and the debate about the petition. It leaves so much for us to all learn from going forward as elections will continue to be held in our democracy in Ghana. I would like to, before I sign off, I'll say that on 31st March, we have another of our leadership program coming up, which is the commemoration of the International Women's Day. And we'll be having the program between the hours of 5 to 7 p.m. under the team. We have domesticated the international team. So we will be having our program under the team Ghanaian Women in Leadership amidst a global pandemic. Also because according to the United Nations and even records in Ghana, women have not been properly integrated into task forces and committees that are working on the recoveries from COVID-19. So we want to delve deeper into the issues, looking at how women's leadership could have changed the containment measures and the response by government of Ghana going forward to protect every citizen of this country. We want to express our sincere gratitude and appreciation to our panelists who took time off their busy schedules to share with us, for us to learn from, for us to pick advices from, and for us to also know more about politics and learn about the electoral processes through their presentation. We are also very grateful to our participants who joined us from all over the world, and we are grateful and we hope that you will continue to support us in diverse ways for our activity. To my colleagues, I say thank you and good for your man's job. Thank you so much for joining us, and we hope you join us again for some of our programs. Good evening. Soji, are you there? Doc.